all of the proceedings in this matter, or as an alternative, the court prohibit any further electronic media coverage of the preliminary hearing, which includes September 1st.
Thank you, Mr. Novak.
Thank you very much.
Turning to the state and then to the media.
Yes, Your Honor. As to the remedy, we've heard of instances where the media has been able to delay publication of the recordings of the proceedings. We've heard of instances where that has been a short delay of like 30 seconds. I've talked to the media attorney about this, and they do not have the capability to do that right now. My suggestion would be for future proceedings to order the media to look into that capability, and that would be a remedy that perhaps could be used in the future. I think that would be a satisfactory remedy to avoid this type of thing in the future. As to the other remedies requested, we have one witness. The final witness, well, the defense has one witness. That witness is a ATF DNA forensic biologist, and I assume that the exhibits that will be admitted through her will be of that nature. We've already, in fact, admitted the report that she is going to be testifying to. The reports, I should say, that's exhibits 30 and I believe 34. And so I don't think we have, and those have already been published, I don't think we have the same risks or, I'll just say risks with her testimony as we do with some of this other evidence that has already been admitted.
Thank you. To the media.
In a proceeding like this, the parties in the court and the media are working together to learn and to refine their processes. I hear Mr. Novak's remarks about challenges that we've run into in the past. I recall, it hasn't been that long ago, a time when the camera was placed in a location in the courtroom that was causing challenges. The court moved it. When there were challenges with aspects of the court's ruling, the court reiterated those, and those processes improved. We are getting better at this. Media is on board and recognizes the court's obligation and its significant efforts to balance the interests here. In light of the court's ruling, including its recognition that the media operator in this case beat almost all of us to the punch, right? And saw what was happening on the screen and moved away as quickly as they could. We believe that the procedures that the court currently has in place, even if they don't, every moment of every hearing deliver the result that we are intending to deliver. Those processes are working. I don't believe that a further adjustment, much less a sanction, much less a revisitation of something that says let's keep every photographer, every camera out of this courtroom for every proceeding, in light of the court's well-reasoned and exhaustive rulings after long briefing on all of this. The court is currently balancing these interests correctly, and we therefore ask the court to allow the parties to recognize that the time we're dedicating this morning represents a reiteration of the importance of these principles. The media and the parties all recognize that, and we'll continue to endeavor at all times to do all that we can to ensure that those are adhered to, and let the parties go forward under the current procedures without further order or sanction by the court.
Thank you. Any further arguments before the court issues its ruling?
No, but thank you for the opportunity.
Thank you. And just updating my notes as I'm intending to issue this ruling right now. I'm just making sure that I'm capturing all the points made in the argument right now. almost done. I appreciate the party's patience. This issue rises to the level that necessitates great care. And as my practice, I don't like to rush or make snap decisions, and I want to give this the full analysis that it's due. So thank you again for your patience. All right. Court will issue its ruling on the request by defense. The constitutional rights of Mr. Robinson and Ms. Kirk are paramount. Although transparency in judicial proceedings is a fundamental interest, it must be balanced against the constitutional rights of all parties. Having considered the arguments presented by counsel and having reviewed the events that occurred yesterday, the court finds that its order prohibiting the publication or broadcast of Exhibit 16 by the media camera was violated. The court agrees with the defense that this constituted a violation of the court's order. Compliance with court orders is essential in all proceedings and is of particular importance given the nature of these proceedings. With respect to defense's request as a sanction that the court reverse its ruling on defense motion 305, motion to exclude cameras, the request is respectfully denied. The analysis underlying the court's prior ruling remains unchanged, and the court adheres to its reasoning and conclusions. With respects to the defense's alternative request as a sanction to prohibit all cameras and electronic equipment from today's proceedings, thereby preventing the electronic capture of the proceedings for those inside and outside of the courtroom, the request is granted in part and denied in part. Effective immediately, members of the media shall no longer capture or broadcast any exhibits displayed by the parties during today's proceedings. The court finds this sanction to be proportional and appropriate in light of the violation of the court's prior order. The court reserves this sanction as it relates to September 1st. It is not before the court. There has not been a request for electronic media coverage, and the court won't issue a pre-ruling. When it becomes, that request has been filed and all the deadlines which the court has imposed in regards